talking about competition and intellectual property rights and their relationship in general terms, and then I will go to a specific example of the the relationship between intellectual property rights and competition as currently understood by the courts in the United States, and attempt to show you how that understanding is entirely incorrect and how a correct understanding would have a surprising effect on the relationship between intellectual property rights and competition policy. Intellectual property ownership has become a critical issue in current debates concerning not only national competition policies, but also international trade and development. Why have intellectual property rights, IPRs, become the overriding issue in these intertwined debates? Simply put, because all three, competition, trade, and development, call for attempts to mediate between stronger rights to encourage innovation on the one side, and on the other, better access to increase its dispersion. Given my time allotment today, my paper focuses on national competition policy and the status of IPRs. In the U.S. debates, the dominant view holds that stronger IP protection leads naturally to more innovation, more competition, and more economic growth. Given the dominant view, it is easy to forget that there is nothing natural about IPRs, and that they are, after all, state-initiated restraints of competition. But IPRs have not always been held in high regard in the United States. When the U.S. Congress passed the first National Patent and Copyright Acts in 1790, the statutes were viewed as necessary evils, as state-created monopolies to be minimized. This attitude persisted a century later when the Sherman Antitrust Act, the National Competition Statute, was passed. More recently, however, the relationship between IPRs and antitrust has been turned on its head. Since the 1980s, not only have IPRs been strengthened, but antitrust enforcement has been diluted. Now, IPR ownership immunizes much anti-competitive conduct from antitrust scrutiny. My paper addresses two questions. First, what explains the reversal of fortunes, the decline of antitrust, the elevation of IPRs to primary importance, and in consequence, a weakened commitment to free competition? Second question, how can the benefits of free competition be reintroduced into the policy debates concerning IPRs, debates, after all, concerning the public benefits from advancing economic growth and from promoting fair distribution of its benefits? These are large questions that deserve more attention than I can give today, so this paper is an introduction to the issues, their development left to another day. The first question, given the powerful rhetoric of free competition in the U.S., what can explain the 30-year decline of antitrust and at the same time the expansion of IPRs despite their clear character as state-initiated restraints of competition? The place to begin is the rhetoric of free competition. What exactly do we mean by free competition? The answer becomes clear once we restate the question as follows. What exactly is it that we want to free competition from? In the United States, this question has long summoned two responses. First, we want to free competition from the political control from oppressive government intervention. In this sense, free competition expresses a commitment to individual liberty. Second, we want to free competition from private economic control, from the oppressive government of accumulated private capital. In this second sense, free competition expresses a commitment to rough equality. In some, free competition, the rhetoric of free competition, reflects commitments to both liberty and equality and concerns about oppressive power, both political and economic. It turns out that these commitments to liberty and equality at least sometimes produce a fundamental tension in the idea of free competition. when free competition's commitment to economic equality calls for government intervention to curb private economic power, that very government intervention infringes on free competition's commitment to liberty. As distrust of government intervention has grown in the U.S. since the Vietnam years, that distrust has surpassed progressive concerns for economic and commercial inequality. In consequence, the dominant ideology in the United States today favors free markets in the belief that they are better left alone than supervised by distrusted government, whether the supervision is by antitrust enforcement or direct government regulation. Despite this distrust of government, the very same forces have driven the simultaneous rise of intellectual property rights, even though they are undoubtedly state-initiated restraints of free competition. How? Well, first, IPRs infringe on free competition's commitment to equality insofar as they grant IP owners the private power to pursue economic monopoly. Second, IPRs infringe as well on free competition's commitment to liberty since they result from direct government intervention. But here, the distrust of direct government intervention has not taken hold. So, what has led modern U.S. policymakers to expand IPRs despite general distrust of government intervention into commercial markets? Well, there are at least two different conceptions of how IPRs are justified and how their expansion is justified despite their character as government-initiated restraints of free competition. First, some have viewed IPRs as natural rights. Second, others have viewed IPRs, patent and copyright in particular, as constitutional entitlements, as pre-governmental rights to encourage innovation. In both views, the government's active role has fallen out of the picture. First, IPRs are broadly understood as a compelling form of natural property rights. Their moral foundation is especially appealing because they satisfy not only John Locke's labor theory of property rights, but also purport to reward the romantic genius of the individual imagination. In this light, the government is not seen as the source, but rather the protector of morally ex ante IP rights. Thus, any expansion of IPRs is seen as fuller protection of perfectly natural rights, while any narrowing of IPRs is seen as oppressive government restraint of the natural workings of competitive markets. Second, there is the dominant scholarly and jurisprudential view of patent and copyright as constitutional rights, ex ante rights enacted but not created by government. In fact, the U.S. Constitution does empower Congress to enact patent and copyright protection for the specific purpose of advancing knowledge and industrial technology. And so patent and copyright are properly understood as the private means to produce the public benefits of inventive activity. This constitutional conception is supported by an intuitively attractive economic view that IPRs provide the necessary financial incentive for inventors to invent and for investors to invest in research and development. And when they do, all of society benefits from the economic progress that results. Though the natural rights view is popular, it is the constitutional rights view that dominates scholarly and policy debates in the U.S., the view that patent and copyright are the private means to promote the public benefits of innovation and economic growth. So it's worthwhile for us to investigate for a moment the economic incentive logic that has come to dominate the constitutional rights view of patent and copyright as the private means to produce the public benefits of economic progress. Although the economic incentive rationale for patents and copyrights is intuitively attractive, the fact is that it simply does not hold because there are deep problems with the logic. First, there are theoretical criticisms that go back almost a century. To begin, there is no logical basis for the general assertion, or any general assertion, that increasing the means increases the ends. To equate them is a logical category error. Then there has been the more focused criticism that incentive theory does not take into account what are called economic opportunity costs. That is, it does not account for the lost profits of alternative investments, the benefits that would have resulted from investment in, for example, more production or better infrastructure. That's the theory. In addition to the theoretical criticisms of incentive theory, over 50 years of economic studies have failed to find empirical support for an incentive theory of patent and copyright. Let me be clear about this. Despite 50 years of trying, there is no empirical evidence to support the view that economic benefits of intellectual property rights are worth their economic costs. Nothing to support the view that IPRs are superior to free competition in the production of innovation or the advancement of economic growth. In sum, the private benefits of patents and copyrights, to inventors and investors tell us nothing about their effects on the public good. Still, the economic incentive theory continues to dominate political and scholarly debates. I think there are at least two reasons for this unearned success. First, there is a neo-mercantilism that runs through the political debates in the United States, a belief that IP protection is the last great hope of the United States for competitive advantage against the onslaught of globalization. Of course, even if this is the case, it's not clear how long the current balance of trade in IPRs will continue to benefit the United States. Moreover, Adam Smith taught us long ago that maximizing private profits does not maximize a nation's wealth. The second reason for the continuing dominance of economic incentive theory is related to the first, and I've sort of mentioned this already. There is a persistent category error of equating means and ends, of equating private profit with public benefit. And so, despite a century of scholarly criticism, too many scholars and judges in the United States still proceed as if maximizing patent rights serves to maximize innovation and, with it, economic progress. While the U.S. IP debates have only begun to include arguments about fair distribution, arguments voiced by in the human rights community, criticisms of the incentive story have actually begun to take hold in recent years, very recent years, in mainstream IP literature, and it also has begun to reverberate in recent Supreme Court decisions. These recent developments open the door to my second question, and that is, how can the benefits of free competition be reintroduced into the policy debates concerning IPRs, debates addressing the public interest in advancing economic growth and, sometimes forgotten, promoting fair distribution of its benefits? I believe there are competition policies waiting to be applied, neglected competition policies that are already at hand. The surprising source for these neglected competition policies lies within the IP domain itself. As I've shown in a series of papers that I've written over the last few years, while patents are, in fact, state-initiated restraints of competition, patent policy is shaped by its own fundamental commitment to free competition. The same can be said of copyright, trademark, and trade secret policies. My paper concludes with an example of patent policy's fundamental commitment to free competition. My example will serve two purposes. First, it illustrates one important way that competition policy shapes patent rights. That way, you don't have to simply take me at my word. Second, it shows how antitrust courts should apply patents competition policy and, in consequence, reformulate their understanding, antitrust understandings of patent rights, which is now a misunderstanding that excessively restrains free competition. Let me say, by the way, that when I refer to antitrust courts and patent courts, I'm referring to the very same courts. In the United States, the federal court system has jurisdiction for both patent and antitrust cases. When I talk about a patent court or an antitrust court, all I mean is a court sitting in an antitrust case or a court sitting in a patent case. It's the very same court, and indeed it could be the very same judges, though it's hard to believe since they tend to forget. My example describes how attention to a recent and highly influential patent decision by the U.S. Supreme Court would correct one widespread mistake that has resulted from antitrust policy's overly deferential attitude toward patent rights. Antitrust courts have consistently and mistakenly concluded that as a general matter, patent ownership automatically justifies a dominant firm's refusal to deal so long as the refusal lies within the scope of the valid patent. Why? Because it is the patent owner's fundamental right to deny access to the patented invention. But these antitrust decisions have failed to separate the question of a patent's validity from its power to exclude. It is this very distinction between the right and the remedy, its validity and its power to exclude, that provides the logic for the influential Supreme Court decision that I'm going to discuss very briefly, the decision in the landmark eBay case. In that case, the Supreme Court made it clear that ownership of a valid patent does not automatically justify an injunction to halt the infringing conduct. Rather, in determining whether to issue an injunction against an infringer, judges must apply traditional principles of equity to balance the private and public effects of halting the infringing conduct. To balance the public and private effects of issuing the injunction. Since the eBay decision, patent holders have found it much more difficult to persuade courts to restrain infringing competition from selling their patented inventions. As a result, more infringers continue to compete against the patent owner with the patent's very own patented invention. Of course, the infringer does not get away free. They must pay damages and reasonable royalties, but they are permitted to compete. It's compulsory licensing, isn't it? Although the Supreme Court's eBay opinion has widely influenced lower courts in patent infringement cases, the decision has not been understood in competition terms, and in consequence, it has had no influence on antitrust decisions involving the competitive effects of patent ownership. Yet it makes perfect sense that patent law's approach to injunctions should be imported into antitrust analysis of refusals to deal by dominant firms. Why? Because the legal questions in both cases and the economic stakes are precisely the same. In both, whether we're talking about a patent infringement case and an injunction, or if we're talking about a refusal to deal based on an argument that a patent right allows that, in both, patent owners seek judicial authorization to restrain competition on the logic of patent ownership, on the logic of patent rights to exclude. So, what would patent law's competition logic look like in an antitrust case involving a dominant firm's refusal to deal? In a well-known case, Xerox persuaded the court that its patent ownership justified its refusal to sell patented replacement parts to competitors who service and repair Xerox copiers. If the equitable approach taken in the Supreme Court's recent patent decision were imported into this antitrust case, then patent ownership would not automatically excuse the refusal. Rather, Xerox would have a burden of persuading the court that its refusal to sell replacement parts to independent service companies should be permitted in the circumstances. To determine whether the refusal should be permitted, the court would apply patent law's competition logic of equitable balancing. This traditional equity approach requires the court to evaluate and then balance four factors to determine whether the restraint would be fair in the circumstances. First factor. Xerox would have to persuade the court that it would suffer irreparable harm if it was required to sell its patented replacement parts to a competitor. In this case, irreparable harm was not likely. First of all, there was no foreseeable harm to Xerox's reputation for making copiers. After all, it was not selling to competitors in the copier market. But what about the loss of market share for repair service? The independent service companies obviously could not compete in the market for repair of Xerox machines if they didn't have access to the replacement parts. So allowing independent service companies to enter the market would mean a loss of market share to Xerox. Xerox, however, would lose market share not because of the compelled sale of replacement parts. They would lose market share only if their services were inferior or if its prices were higher. And that harm results from competition on the merits, not from free riding on Xerox's accomplishments. But what about Xerox's lost monopoly profits on replacement parts? Applying the second factor of the analysis, the equitable analysis, Xerox would be permitted to refusal to sell only if damages, a legal remedy, would not compensate adequately for lost profits. But of course, damages are viewed as adequate compensation for lost profits all of the time. And moreover, here profits would be lost only if Xerox sold replacement parts to independents at wholesale, something they wouldn't be required to do. Moreover, profits might actually increase if better quality service resulted in greater sales of replacement parts. Third factor, would a requirement to deal imposed on Xerox, a requirement to deal with competitors impose greater hardships on Xerox than a refusal would impose on the independent service competitors? And here we have the balancing. The harm on one side to Xerox, harm on the other side to the refused independent service companies. Here, a requirement to deal would impose a hardship on Xerox only if the production of parts could not meet demand, and that would not be a hardship here, unlikely, particularly because parts manufacturers typically outsourced, and Xerox would not have a problem with that. On the other side, given the typical lack of interchangeability, for example, Kodak parts don't fit Xerox machines, Xerox's refusal to deal would cause great hardship on all independent service companies and thus on competition more generally in the repair market for Xerox copiers. Small burden on Xerox with the imposition of a requirement to deal, significant burden on independent companies if they did not have access to the replacement parts. Fourth and finally, what would be the effect on the public interest? This is the fourth factor in an equity analysis. What would be the effect on the public interest of permitting Xerox's refusal to deal? Given U.S. antitrust's identification of public interest with consumers, the inquiry would address the narrower question of the impact on consumers. In the short run, antitrust's traditional static efficiency analysis would likely conclude that permitting the refusal would harm consumers by leading to higher prices and lower quality in the market for the repair of Xerox copiers. In the long run, the dynamic efficiency analysis associated with more recent antitrust policy and traditionally associated with patent policy, by the way, dynamic efficiency analysis would look into the impact not on price and output, but rather on innovation. The traditional answer here is that a loss of monopoly profits would lower Xerox's incentive to innovate, and in consequence, social welfare would be harmed. But as I mentioned at the beginning of my paper, economic analysis has shown that traditional incentive theory is unsupported in theory or in fact. So even if Xerox might be better off, that does not mean that there will be less innovation. That does not mean there will be less progress. In fact, society might be better off. Why? Because competition provides its own incentive to innovate, but without the social costs of monopoly profits. So the equitable balancing of these four factors derived from patent law's competition policy, applied to an antitrust analysis of Xerox's refusal to deal, would impose a burden on Xerox to show that the factors clearly weigh in its favor, but they don't. There is no harm to its reputation. Lost profits are compensable by damages. The balance of hardships clearly falls on not on Xerox, but on the independent service companies who have no alternative source of supply. And finally, the public interest here defined in terms of consumer benefits of lower prices, better service, and continued innovation all weigh on the side of requiring Xerox to sell repair parts to independent service companies. In sum, the competition analysis imported from the patent regime for a rejection of Xerox's antitrust claim would import competition policy into the antitrust domain. Recall that the court in the actual case viewed patent ownership as an automatic business justification for Xerox's refusal to sell replacement parts to the independent repair companies. The result was no competition in the market. This mistaken view of patent rights and their relation to antitrust policy underlines the importance of taking antitrust to the patent school of free competition. So, finally, we started with a patent, a state-initiated restraint on competition, and applied its logic to an antitrust case, with the effect being state-initiated cooperation between a dominant firm and its rivals, and with the patent logic's ultimate result being state-initiated competition.
I'd like to invite Mr. Chakravarthy, a competition policy and law consultant from India, and he will talk about benefits of competition policy in public procurement with special reference India.
May I say the first hello to the students. May I say the students are like my sons and daughters, or if I may say so, grandsons and granddaughters. I find that the Brazilian girls are very pretty, but before you mistake me or get worried, I may very hasten to add that I am already 74 and out of mischief. Now, second hello to Mr. Bagoli, Professor Drexel, and Ascola for having invited me and given the honor of presenting a session this evening. The third is to our friends on the dais, the chair particularly Fabiano Masso, and also my colleague panelist, Mr. Rudolph Peritz. A last session and the last speaker in the last session is always a problem for the speaker. I have to keep you engaged. So what I propose to do is, I'll be very brief with my slides within about 25 to 30 minutes, out of which the last few slides will make it very light for you and you might perhaps enjoy them. I sent my paper and slides to Professor Drexel and Mr. Bagnoli, and I'm sure it will be communicated to you either electronically or otherwise. And in case you desire to contact me, my last slide will provide the email ID, and you are welcome to get in touch with me. Now I go on to the subject straight. I'm a little unused to this, so I'm a little confused at the moment. My name is Chakravarthy. In fact, the chair was finding it difficult to pronounce my name. Chakravarthy is my name, and for some of you who would like it difficult to pronounce, you can call me Chuck, I have no problem. And I was actually associated with competition policy as a member of the Competition Commission in India, and later in the WTO Committee on Interaction between Trade and Competition Policy. So I've been in touch with this competition for some years. Now I'm going to deal with public procurement. I'm calling it PP for brief. Procurement generally for on behalf of central government. If there is a state, a country with the central government and provincial governments. You can call it central government, provincial governments. Public sector undertakings, I call it PSU. Some commentators and speakers said SOE in the morning. Public bodies. PP constitutes about 10 to 15% of total economic activity. The public procurement itself constitutes about 10% or more of the total economic activity of a country. And it is a substantial proportion of the GDP also. Now, public procurement suffers from the following problems: discrimination, bid rigging, corruption, on which I'll deal with it in my last slides, which I said will be a little light for you, clientism, barriers to trade. In many countries, particularly the developing ones and the least developed ones, these problems are larger than in the developed countries. Competition can be a possible trump for all these problems. You can see the 5 bullets here. Competition policy and law have a crucial role in public procurement operations. They frown on cartelization, collusive practices like bid rigging. Competition policy and law remove barriers that impede healthy transactions. They impel good governance, a positive thing. Competition policy can impel good governance. Competition policy can subserve citizen interest, consumer interest like you and I, and welfare through lower prices, better quality, and enhanced efficiency of supplier firms. In sum, competition can trump public procurement ills. What are the benefits of a competition-driven public procurement regime? 1, cost savings of a transparent, competitive public procurement regime can be substantial. Cost savings itself, if you can have a good public procurement regime driven by competition, it can save a lot of costs. Benefit flowing out of competition-driven public procurement is estimated at $10 billion. This is the chairman of Competition Commission of India attended a conference in Russia, and at that meeting, this particular point was made, and it was communicated to many people in a book also. Additional procurement opportunities for Chinese Taipei, for instance, in 2009 was the order of $20 billion. This is taken from Anderson Ocella's article in one of the books. So you can see there are benefits flowing out of a competition-driven public procurement regime. An appropriate instrument for promoting competition, transparency, integrity. Please note that word integrity. I'll come to that later. Enhanced value of money in public procurement regimes. An appropriate legal instrument is a sine qua non. It is imperative. What does the instrument have to possess? What should it inherit? 1, the instrument should mandate increased level of competition, transparency, and discipline in the public procurement regime. It should say you must have competition, you must have transparency, and you'll have to follow a discipline. It should provide fair and clear procedures. So if the procedures are not clear, there is a potential of mischief makers to rig the bids and so on and so forth. The instrument should seek to increase efficiency in procurement agencies. The procurement agencies, the government agencies, government entities will have to be put on a call. You have to increase your efficiency. Check corruption. Save costs. There are some more. Limit discrimination in awarding tenders. If you have a very clear, transparent policy driven by competition, clear procedures, then you will not be able to discriminate in awarding tenders to your own friends and cronies. incorporate national treatment in the law itself, in the regime, provide for transparent framework of laws, regulations, procedures, and practices so that no mischief monger can have any potential to do mischief. So an appropriate instrument. Now I told you what instrument should have. What is that appropriate instrument? One, there is one which comes to my mind directly is the WTO agreement on government procurement, which is called GPA. It is one. Then you could have perhaps in a country a bilateral agreement with another country. Third, you can have a regional agreement, regional trade agreement as a third possibility. And a fourth, unilateral model law is also adaptable if any country wants to do it. So you have some choices. GPA is one which comes to my mind because it is a WTO agreement. What is GPA? It is a plurilateral agreement. Plurilateral agreement, as all of you know, is one where only those members who have signed that agreement are a party to it, and all other members who have not signed the agreement need not get bound by the GPA. There are 41 countries of WTO, members of WTO, who are signatories to the GPA. A signatory country, if supposing one country has signed, has legal guaranteed access to procurement markets of other signatory countries. If supposing country A has signed it, the country A has the other markets, B, C, D, E, all signatories, their markets are open to them for procurement. Likewise, the reverse. Other signatory countries gain access to the procurement markets of a signatory country. That is, if a country A is signed, all other countries will have access to your country A. That is obverse of the second bullet. Third bullet and second bullet are obverse of each other. India, I mentioned to you that my topic today, I'm going to deal with public procurement, government procurement policy with special reference to India, to which I belong to. India has traditionally followed a hierarchy of preferences in government procurement. One, this is, I would say, pre-1991, before the economic reforms were ushered in, we had a particular regime. That regime, I normally call it LPG, not LPG gas, LPG, which is, in a sense, the government controlled decisions. There is planning, the P stands for planning, and after 1991, the new LPG is coming, which is liberalization, privatization, globalization. The former LPG before 1991 is licensing, planning, government control. That LPG, that paradigm, has shifted to the new LPG, liberalization, privatization, and globalization. Now, this particular thing basically is the pre-1991 old LPG. One, goods produced in India will be preferred. Goods manufactured in India from imported materials will be the second choice. Third, goods from foreign manufacturers held in stock in India. And fourth, imported products. So the position is that basically it was protective of the Indian manufacture, Indian domestic industry, in a sense, home-grown industries. The order of government procurement, what is the size in India? Globally, government procurement averages 10 to 15% of the total economic activity. I mentioned in the first slide. Number two, in India, the range is higher. It is, I believe, 25% now of the role of public companies in key sectors. That is because the railways is one of the biggest public sector undertaking in India. World Bank estimates that the value of Indian procurement markets is the order of $100 billion, which constitutes more than 20% of the GDP. Now, preferences in government procurement. Once the government procurement is there, such a high order, what does the government do? Government policy provides for two kinds of preferences. One is purchase preference, two, price preference. In a purchase preference, you say you have to purchase only from the small and medium enterprises. Or you say that you purchase from the handloom and cottage industry sectors. In a price preference, you purchase from public sector undertakings, even if supposing a public sector undertaking quotes 10% higher than the lowest quotation. Then the public enterprise is asked to come to the negotiating table and say, and told, you also reduce your thing by 10%, we'll give the order to you. Even if you are quoted 10% higher, you make them come down 10% to match the best quotation, and then the order is given to the public sector undertaking. That is the price preference. So the rationale for the preference is social responsibility. In my country, we have certain social responsibilities like taking care of the underprivileged, marginalized sections of society, vulnerable sections of society, impecunious people, certain historically disadvantaged sectors like scheduled castes and scheduled tribes. These people are given special protection, a special dispensation in the law and even in the Constitution of India. So the rationale is social responsibility. So preferential policy protects small scale industry, handloom industry, cottage industry, women's employment schemes, etc. Procurement policy is designed to help direct employment of the marginalized groups, backward areas. As I mentioned to you, the special dispensation given to the marginalized sections of society is that if you give the order to a particular entity which will provide employment to these people, that is preferred. Regulatory apparatus for government procurement. In India, what is the procedure? I don't want to go into all the details. I'll very simply give it to you. There is no single law, but there are what are known as general financial rules, then delegation of financial powers, a manual on policies and procedures for purchase of procurement, public procurement, government orders. You're not here. Okay. This I had to go there. What can I do? Right. I'll try. Right? Is it clear now? Okay. Thank you. There's a manual on policies and procedures for purchase of goods. Government orders on price and purchase preferences. I mentioned to you the difference between purchase preference and price preference just now. Guidelines of the Vigilance Commission. All these things constitute the regulatory apparatus in India for government procurement. Overview of the Indian procurement system. Comprehensive legislation is not there. The bid challenge mechanism is not vibrant. Supposing you are disappointed, you did not get the tender, you want to challenge the government order. The challenge procedure is not vibrant. It is incomplete or dilatory, very, very long. Suppose you go to a court, takes 10 years, 15 years, by which time you are, this morning, Professor Drexel gave an example of McGill. He said after so many years for the decision to take, McGill is rumored to be perhaps on the decline or something. He mentioned this morning. Lacks transparency, fairness, efficiency. These are all the analysis of the Indian system. Cancer of rent seeking and corruption in procurement is a big cost to the consumers. It's a shame to me to say that India, maybe many countries, even including developing and developed countries, they also suffer from corruption. But we do feel that corruption has gone beyond the tolerance limit in India. It is pretty bad. India's accession to GPA. India is today only an observer. We are not in the plurilateral agreement. We have not signed it. We are only an observer. Earlier, we were not even an observer, now we have become an observer. India has not accorded acceptance for accession. Any decision in favor of accession requires evaluating the benefits against costs of accession. Let us look at the pros and cons of accession very quickly. Benefits: 1, accession will secure better value for money spent by the government on government procurement. The causal factors are increased level of competition, transparency, and discipline. GPA is likely to increase efficiency by providing fair and clear procedures. These are all benefits. GPA will checkmate corruption and rent seeking. Broadly, GPA can lead to benefits of increased competition in terms of lower prices, better quality, innovation, technology transfer, and more efficient firms. A few more benefits. It provides framework of laws, regulations, and procedures. Bid challenge mechanism will be there to give redress. Procurement will be on objective criteria, thereby reducing cost. Consequent of accession, India will have legally guaranteed access to procurement markets of other countries, and likewise, other countries will have access to the Indian procurement markets. These are all the benefits. What are the costs? Oh, one more is there. This is very general. Accession will send powerful signals to governments and foreign investors that there is a commitment in India to the principles of transparent, fair, and competitive procurement markets in India. Now, what are the costs? Indian government uses preferential treatment in government procurement as a tool of industrial policy. I mentioned to you the protection to small-scale sector, handloom sector, and PSUs. But GPA mandates non-discrimination and national treatment requirements on tenders, so India's policy is likely to be held as restrictive. So that's a cost. Second set of costs, state governments like provincial governments, they don't have the capacity to adhere to GPA commitments. Weak state laws suffer from loopholes. Procurement regimes take advantage to beat the mandates. There will be financial costs in implementing. See, if you want to have a GPA, you have to have a structure, you have to have an apparatus which will cost you money. All that will have to be borne by the Indian government. Concluding remarks on this before I go to the lighter ones. While the benefits of accession would be welcome in terms of good governance requirement, the costs and risks and the political backlash had to be reckoned before any final decision is taken. The political backlash can be very severe in India. We have a very strong opposition, and we are always on the tenterhooks as to whether any policy can easily go through. GPA provides for positive discrimination where justified. We can also invoke some of the provisions in GPA which permits developing countries to have certain exclusions, exemptions, and so on. For positing discrimination, India has identified the sensitive and critical sectors that is provided in GPA. You can identify them, and then that will be excluded from the operation of GPA. Fourth bullet, once they are identified, India can negotiate offsets. We can say, I am giving you this, give me this. Final, India could avail of special and differential treatment provisions of the GPA. So these are all the main things. India could shake hands with GPA. India's decision to become a GPA observer is a first step, is a pointer that it has identified benefits of accession. India will have the advantage of access to other parties' markets. Likewise, other countries will have Indian markets. And finally, a transparent, fair, and effective domestic procurement system is likely to result. Competition, an antidote for corruption. Measures aimed at increasing transparency would minimize, if not prevent, corruption in public procurement. Such measures, that is, if you have a competition-driven process, it will prevent corruption. Such measures are not only compatible, but supportive of the promotion of competition. Measures aimed at preventing corruption and promoting competition are mutually reinforcing, have both prevent corruption and promote competition. Some cartoons, before I bow, to add a little spice to the serious topic. Here are a few cartoons, 6 of them on corruption. Look at that. He's talking on the microphone. Now that I have retired, I promise to restore moral values, rid the system of graft, bring back Gandhian principles. When he was in power, he didn't think of those. After he has retired, he is promising these things. Now the father talks to the son. You are new to politics and therefore worried about corruption charges. CBI means Central Bureau of Investigation probe, special court order, and so on. Nothing will happen, I assure you, father tells the son. Because in our case, in our courts, things go on for years. Nothing really happens ultimately. Dad, the son says, I am considering a career in organized crime. Father says, government or private sector? Now, these two chaps are talking to each other. With videotapes, websites, and so on, bribe taking is going to be quite risky, unlike our times when we did not have all these gadgets. And another thing that made me happy was that I learned corruption was a global phenomenon, not particular to India. It's a global phenomenon, let it be there. How does it matter? That's what two people are talking to each other, politicians. Here is a cabinet room, the chief minister or the prime minister sitting at the end. At last, he has removed the ministers with tainted reputations of the cabinet. All of them are tainted. All of them are removed and he alone is sitting. That is what he says. Optimistic finale. Alas, corruption has been ubiquitous in the public domain. But yet, now its antidotes may emerge from that vast crucible called competition.
In thinking about what I've heard all day today, I go back to thinking about what the economists have done to antitrust, which is to tell us that it's all about models, it's all about economics. But no, it's about political economy. And what have we been hearing about competition? We've been hearing that governments are competitors. They're competing within themselves. In China, we hear about 3 different agencies competing for the power. We hear about competition between the central government and the regional local governments. And we can apply this in almost every country and in almost every context. It's like we've got various groups competing for power over economic decisions. We just heard that industrial policy is one of the reasons why government doesn't want to give up its controls. So all I'm saying is that we're learning about the necessity of putting politics into the economic thinking about what's going on. It's really about who, it's not just private organizations competing with one another. It's within this larger context of almost a variety of organizations, some public, some private, some combined, that are all competing to see who's going to make the economic decisions that ultimately have political implications.
You already think about opening the Indian procurement market to the world and to competitors from outside. India shares some features with other emerging economies, also with Brazil in particular. Both countries are federations. And you also mentioned that the local governments play an important role. And if you think about the European situation, you may learn something from the European situation. Wouldn't it be a good idea to start with the internal Indian situation and first implement a national public procurement policy that addresses in particular privileges given by local governments to local companies? And I guess that corruption is especially taking place on this level as well. And so once you have implemented working public procurement policies within India, especially maybe addressing the local governments, then maybe you can think a little bit further. And obviously there might be the argument that there are some social considerations and so on which might need some protectionism, although I do not really want to argue for protectionist policies. But maybe that's the first step in this direction. And Europe has exactly done this because public procurement law in Europe started from internal market policies. And it's probably one of the fields where European policies were most influential for creating a level playing field across EU member states. Then to Rudolph Peritz, we had a discussion yesterday evening about eBay. I would like to add a few further remarks. Your arguments about eBay and antitrust law and how the two rules compare also is a topic about which I have thought for quite a bit of time. And I would like to add 4 different additional considerations. One is, the first one is one which I mentioned yesterday, so I apologize to you, but the rest should know about it. If you make the point that eBay maybe is an antitrust decision in substance, yes? And why doesn't US courts repeat within antitrust the basic considerations and the balancing that was made in eBay? And of course, the rule that would have to be applied in the field of antitrust law is Section 2 of the Sherman Act on monopolization. And here, it seems to me that eBay is a broader rule in different regards. And number one is the argument I brought yesterday. Section 2 only addresses cases of exclusionary practices. In eBay, the patent holder did not want to enter the product market. What the patent holder wanted to achieve is to extract very high royalty rates. So this might be a European competition law case, but not a US antitrust case, because Section 2 does not protect against exploitative abuse. European law does with Article 102. So maybe eBay even goes further. It somehow addresses an issue which is recognized as a competition law issue in Europe, but it is not under Section 2 of the Sherman Act. Point 2, Section 2 of the Sherman Act requires monopoly power. This is a consideration which was not brought up in eBay. I also always discuss with my students the eBay case in the framework of my competition law class, and we always discuss the question whether this particular patent provided monopoly power in the sense of US antitrust law. And more or less at the same time, the US Supreme Court decided Illinois 2, where the court said, we depart from previous case law according to which a patent creates a presumption of monopoly power when we apply Section 2 of the Sherman Act. You have to prove that there is monopoly power. In eBay, it wasn't, the question was not even brought up. So it seems it doesn't matter. So you create kind of a license, with which I agree, without even having monopoly power. It's not a requirement. Point 3, maybe it's wise not to bring up the Section 2 argument because of the remedies. eBay simply says you don't get the injunction. If you make the Section 2 argument, you are arguing a criminal offense. And maybe this goes too far. Yeah? Yeah, or other enforcement or fines, whatever. In Europe, take McGill. You can fine the company. The European Commission fined Microsoft. So these are, or divestiture, which might be a remedy under US law. So these are extreme remedies which you might not necessarily want to discuss in a patent law case. This might be a reason why courts are more reluctant to apply Section 2 as compared to the eBay rule. So eBay in this regard might be a little bit weaker. And number 4, this is a consideration which mostly comes from German experience. Germany recently has produced a number of cases regarding refusal to grant a patent license, because Germany is the major patent country in Europe, and most of the patent infringement cases take place in Germany, and then often the alleged infringer says, but you were on a duty to license under competition law. And we had a number of cases in this regard. And this discussion has proceeded, and you seem to argue that eBay creates kind of a compulsory license. I would say it's a statutory license. A statutory license is even stronger than a compulsory license, because under a statutory license, the other person, the other party, is allowed to use the subject matter of protection right away. The person does not have to ask for a license. And in Germany right now, the debate has gone beyond the requirements for the duty to license. The question is now, what are the procedural requirements for using the patent? Do you have to ask for the patent first? What happens if the patentee refuses to license? Do you have to pay reasonable royalty fees? Are you allowed to question, a very important question also in the eBay case, are you allowed to question the validity of the patent? eBay started with an infringement case, but eBay also questioned the validity of the patent. Under German law, in this situation, once you question the validity of the patent, you no longer qualify for a competition law defense. You lose your defense, which I find very questionable. But these are all the issues which come up if you stick to a compulsory license and not to a statutory license. So there are many, many issues in addition to what you were saying. Thank you very much.
Just a short comment, Joël Moniger. So far as I remember, we all believe in competition. And sometimes we even say, in competition law, we trust, even in the US where they use the antitrust in spite of competition. And sometimes in certain Ascola meetings, we forgot the main element. Competition law is meant to protect consumers. And I think today, what was very striking for me is that we discovered that there is other horizons, other people concerned, and that in certain places we have to take care of citizens. And as Joseph said, politics is necessarily present in any system, at the beginning of the choice of the system, secondly in the application. In the EU, we never say that. Don't repeat it, it's a secret. We have decisions on mergers, which are industrial policy decisions. I remember one, which is Mercedes-Cars-Bohrer. It was a question to save 600 jobs, and Mercedes was only required to do what the government decided. Well, it was pocket money anyway. But so I think that's very important. And you said in your final speech also that we have to take care of different situations. It was said also for Brazil earlier. And that's something which is very important for people who are too technical. We have sometimes to go on the cloud and to dream. And that was very good to dream, even if dreams cannot be protected by IP. Thank you so much, all of you.
I would just like to talk about, just for a moment, what Joseph was talking about. And I think I agree pretty much with what you were talking about. We discussed this yesterday evening. But I think there's one comment that you made that I want to clarify, which I think is a little off the mark in terms of what my intentions are. And that is that I don't intend to characterize eBay as an antitrust case. I absolutely do not want to do that. In fact, I want to differentiate it from antitrust. I want to characterize it as a patent case. I want to characterize it as a patent case and as an example of how the patent domain has its own competition policies. Different from antitrust, just like copyright has its own competition policies, trademark has its own competition policies, and they're indigenous to the domain. So, in my view, eBay is not an antitrust decision. And I think its virtue is that it's not an antitrust decision. And so what I did was attempt to bring it into antitrust analysis in a very particular and narrow way. I attempted to bring it into antitrust analysis to deal with one particular narrow question. Under Sherman Act Section 2, one has to plead and prove dominance, and you talked about that. But monopolization is a conduct offense, so that after proving sufficient market power to satisfy the requirement for dominance in the United States, the second element is to prove predatory intent, and that's always an inference from conduct. And the specific example that I took is the example of a refusal to deal. And I chose the example of a refusal to deal because in the United States today, and I think there's a really good basis for this, in the United States today, the antitrust refusal to deal is seen as the most direct and difficult intersection between antitrust and IP, particularly because the fundamental right that patent grants embody is a right to exclude. And so in an antitrust refusal to deal case, refusals to deal in the United States are presumptively prohibited. The defendant, the monopolist, however, can come forward with a legitimate business justification for the refusal to deal. And if the monopolist comes forward with a legitimate business justification, then the refusal to deal is permitted. The perhaps the most common and certainly the most difficult legitimate business justification for a refusal to deal is the ownership of a patent right. And it seems like that's obviously a legitimate business justification. The courts in the United States, Kodak, Xerox, others, have all said, I mean, there's some play around the edges, but what it boils down to is that patent ownership is a legitimate business justification for a refusal to deal. And so I took that very narrow question of whether a patent right should be treated as an automatic business justification. And my view is that if patent law's conceptualization of a patent right, a more nuanced conception of a patent right, which separates out from patent rights from patent remedies, were imported into antitrust analysis, then the word automatic would be taken out. And the antitrust court's analysis, the antitrust court would be required to engage in an analysis to determine whether a patent in any given situation, given the circumstances, given the balance of hardships and benefits, given the impact on the public interest, whether the patent remedy, which is the equivalent to an injunction, right, patent remedy to exclude, should be treated as a legitimate business justification. And so what I'm saying is that antitrust has a very narrow and simple-minded view of what patent rights encompass. And that if the more nuanced, more complex, and now widely accepted view after eBay of what patent rights constituted were brought into antitrust in that narrow issue, we could have a very different outcome. I could give lots of other examples. Another example, I will just mention the example, I won't run through it. Another example where the eBay conceptualization of patent rights versus patent remedies and the lack of automatic connection between them might make a lot of sense is in the antitrust analysis of settlements of reverse payments in settlements of patent cases. You know, in the pharmaceutical cases where branded pharmaceutical companies pay off generic defendants in exchange for the generic defendants' agreement to stay off the market. If you think about what the legal issues are, the scope of the patent, And if you think about what the economic consequences are, staying off the market, they're exactly the same. It's a different doctrinal framework, but it's exactly the same. I could give you 4 or 5 more instances in patent law and then take you through copyright and others of where a competition policy that is expressed in patent law, if brought into antitrust law and understood and applied in those cases as the doctrines are applied and understood in the patent domain, then antitrust judges would have a very different view of what patents entail, and the power of patents to restrain competition would be much more limited. So I want to separate out antitrust from the competition policies that are external to antitrust. Everything else that you said, I'm with you 100%.
Yes, India and Brazil have certain commonalities, like a large country with provincial governments and all that, state governments. We do have them. In fact, some of our provinces, in terms of size, are as good as reasonably sized countries. We have 22 countries put together called India. Now, the national procurement policy is laid down at Delhi, central government, and where it is procured from the state governments also, the same policy will apply. So there's no problem of state policies being in conflict with national policies. But you are right, the state governments have certain policies for procurement of certain other items, not food necessarily, in which there is no uniformity. They are weak in their apparatus, they are not clear in their procedures, the policy is not well laid down, and so on and so forth. That's why I mentioned they have to be geared, they should be encouraged to follow a particular system and discipline. But basically, within the country, Professor Drexel, there is not much of a restriction in terms of movement of goods or food or anything of that kind. So it is fairly liberal that way. So there is not that there is an impediment because the state government, it is generally clear, except that if you move from one state to another state, you have to pay some octroi for the lorry and kinds of things, trucks and so on. But that is there everywhere. But there are no specific barriers otherwise which impedes competition in that sense of the term. But your point is well taken. Thank you.